Hello, everyone. My name is Lindsay Unfiltered, and today we will be finishing that lawsuit from P. Diddy and Ashley Parham. Now, we got through the first 40 pages. Long, arduous process, my friends, but we're going to finish that out. We had a really good first interview with the lovely Hope on our channel. It's the last video. She talks about her experiences in the UK and trafficking through that system. So it's a really good listen. We get really intimate, we get really deep, and we talk about some things that children may go through that we don't see, things behind the scenes, how important it is to check on your friends and family members. So I want to thank her again for that. I really appreciate it. I was super nervous because I'd never done an interview with anybody, but I feel like it fits in with the times right now. We're talking about P. Diddy. We're talking about all of these related things. So to hear someone's story and to relate to them and know that it's a worldwide issue, it's just not an American issue. It means a lot to me that she came up and she gave us a little bit of her time. So thank you again for that. But we're going to finish this lawsuit out. The last 20 pages, we're on the causes of action. So why are they bringing this suit to trial, etc., etc. We're going to finish the rest of the pages today, my friends. And the rest of the week, we're going to be talking about N on our Scandal series playlist and L on our Scandal series playlist. So keep it tuned this week. Make sure you lock into the shorts as well. Follow me on TikTok, follow me on Instagram, follow me on Facebook. I'm going to put those in the descriptions below so you guys can follow me on all my social medias. And without further ado, we're going to finish this out. If there are any other specific P. Diddy cases you guys want me to cover, put those in the comments down below. Or if there's anything in particular in pop culture, scandal, or controversy news that you want me to cover, put those in the comments down below and I'll take a look at those as well. We have 1,810 followers. I want to thank each and every one of you. I adore it. Thank you so much. Without further ado, let's get into the last 20 pages of this lawsuit. Okay, so we picked off on the 10th cause of action, which is negligent supervision and retention, and this is against defendant Diddy. Plaintiffs incorporate by reference and reallege each of the preceding paragraphs and all paragraphs below as though fully set forth and brought in this cause of action. At all times, material defendants KK, Does 1 and 3, and Jane Doe were employed by defendant Diddy under the control and authority of defendant Diddy. Defendants KK, Does 1 and 3, and Jane Doe were unfit or incompetent and posed a particular risk of essaying or mentally abusing Ashley. Defendant Diddy knew or should have known not only that defendants KK, Does 1 and 3, and Jane Doe were unfit or incompetent and posed a particular risk of essaying or mentally abusing Ashley, but also that this unfitness created a particular risk to plaintiff. Defendants KK, Does 1 and 3, and Jane Doe, unfitness and particular risks to Ashley harmed her. Defendant Diddy knew or should have known that defendant Doe 1 had previously engaged and was continuing to engage in unlawful conduct for his own personal sexual gratification. Diddy knew or should have known that it was foreseeable that Doe 1 was engaging or would engage in illicit activities with plaintiff under the cloak of authority, confidence, trust bestowed upon him through Diddy. At no time during the alleged period did Diddy have in place a reasonable system or procedure to investigate, supervise, and monitor defendant Doe to prevent sexual and verbal abuse, SA, or did he implement a system or procedure to oversee or monitor conduct towards individuals they encountered? Defendant Diddy conspired to and did breach his duties of care owed to plaintiff, including by turning a blind eye and encouraging known abuses by defendant Doe 1 and the known dangerous conditions of the enterprise and continuing to expose individuals like the plaintiff to these dangers for decades. Even though Diddy knew or should have known of these illicit activities by himself and defendant Doe 1, he failed to use reasonable care in supervising defendant Doe 1 and did nothing to reasonably investigate, supervise, or monitor defendant Doe 1 to ensure the safety of individuals they encountered. Diddy's negligence in supervising or retaining defendant Doe 1 was a substantial factor in causing harm to plaintiff. As a result of the above described conduct, plaintiff has expended significant costs on therapy and suffered damages including deprivation of income and benefits, loss of employment opportunities, severe mental and emotional distress, pain and suffering, mental anguish, humiliation, loss and enjoyment of life, and damage to her reputation and career. Plaintiff claims compensatory and punitive damages herein. The amount of damages sought herein exceeds the jurisdictional limits of all other courts that would otherwise have jurisdiction. Guys, again, if you don't know how much she's seeking, I believe it's $50 to $100 million that Ashley Parham is seeking for this suit. Yeah, it's a lot of money. It's a lot of money, right? Now, this specific cause of action, the cause of action that talks about, again, I'm not a lawyer. I do not offer legal advice. I'm just giving my unfiltered context clue reading ass opinion, okay? So when we look at negligent supervision, okay, so they are saying that Diddy, you are the boss of these people, of KK and the gang. They're saying, Diddy, as a boss, as a manager, as an overseer, you need to make sure that your employees stay in line. And because your employees are pillaging and hurting these people, you are liable for their actions as their boss. You're negligent in your supervision and your retention of your employees, right? That's what I get from it. Now we have an 11th cause of action against everybody, even the blonde, unidentified woman, right? Defendants conspired to and did engage in conduct that was extreme and outrageous and intentionally caused severe emotional distress to plaintiff. Defendants' conduct exceeded all possible bounds of decency. Defendants acted with the intent and knowledge that plaintiffs suffered emotional distress due to their inexcusable and outrageous conduct. Defendants' conduct caused plaintiffs to suffer physical injury, severe mental and emotional distress, pain and suffering, mental anguish, and loss of enjoyment of life. Defendants' unlawful actions were intentional, done with malice, and or showed a deliberate, willful, wanton, and reckless indifference to plaintiff's right. Plaintiff claims punitive damages herein. The amount of damages sought herein exceeds the jurisdictional limits of all other courts that would otherwise have jurisdiction. 12th cause of action against everybody is negligent infliction of emotional distress. Defendants were negligent by both conspiring to and each breaching the duty of care they owed to plaintiff to keep her safe, and by breaching their duty to properly supervise and control each other, defendants within the Diddy sexual abuse and cover-up enterprise. Plaintiff suffered physical injuries, severe mental and emotional distress, pain and suffering, mental anguish, and loss of enjoyment of life. Defendants' negligence were a substantial factor in causing plaintiff to suffer injuries, severe mental and emotional distress, pain and suffering, anguish, and loss of enjoyment of life. 13th cause of action is unjust enrichment. I have no idea what that is, but we will learn. And this is against defendant Shane, KK, Doe's 1 through 3, and Jane Doe. Everybody except P. Diddy. Defendant Shane received significant revenue, specifically a new car, for his betrayal and his involvement in plaintiff's assault and role in the Diddy sexual abuse and cover-up enterprise. Now, you cannot prove that he got a new car for his participation in this event. You cannot prove that, so you should not put it in the paperwork. Earlier on in the paperwork, like in the beginning of the paperwork, they said he was zipping around in a new car, and Ashley believed that it was payment from P. Diddy to set her up. We don't know that for sure. So to put that at 271, it makes me look at you like you don't know that for sure. If you could prove it, sure, but I mean, rich people give shit away. Or he could have worked for that car. I really don't know. I don't know. Other defendants named herein received significant revenue for their involvement in plaintiff's assault and their roles in the sexual abuse and cover-up enterprise. Defendants appreciate and have knowledge of such benefits and retain them to this day. Under principles and equity of good conscience, you expect that from this group? Okay. Defendants should not be permitted to retain the profit they received and retained at plaintiff's expense while refusing to provide compensation for the injuries suffered by plaintiffs as a result for their unlawful conduct. Okay, I understand what you're saying there. Clock it. Including their failure to guard against, educate as to, or otherwise failure to prevent such injuries inflicted on plaintiff. Plaintiff seeks restitution and or disgorgement of all monies defendants have unjustly received and retained as a result of their unlawful conduct and participation in the Diddy sexual abuse and cover-up enterprise alleged herein. Now, that's going to be tough. That is going to be tough to do. Because she's asking for the money that they've gotten from their unlawful conduct while being a part of this enterprise. How much money have they earned? There's no literal way to track down how much money these people have earned. You can look at their salaries, right? You can dock a piece of their salaries and make them pay a restitution of that. But there's no way to show what percentage of their salary specifically went to this is for you to take out the dirt, do the dirty laundry. Like, I'm going to throw an extra $50,000 on top for you to do the dirty work for me. $50,000 a month goes on your salary for the dirty work. Like, there's no, I highly doubt that something like that is on paper. She says disgorgement of all monies. Who's to know how much money that is, right? 14th cause of action, aiding and abetting against Shane, KK, Doe's 1 through 3, and Jane Doe. Everyone except Diddy. Right? Defendants knew that an assault battery SA was being committed and was going to be committed against plaintiff because defendants' involvement in the sexual abuse and cover-up enterprise. Defendants provided drugs to be used to take advantage of plaintiff without the knowledge or consent of plaintiff. Defendants knew plaintiff had been and would be assaulted because of their involvement in this enterprise. Follow me. Through the aforementioned acts, defendants caused plaintiff an imminent apprehension of harmful or offensive contact with an intimate part of her body, and sexually offensive contact with plaintiff resulted. As a result of the defendant's conduct, plaintiff has suffered economic injury. Plaintiff's general, special, and consequential damages are in an amount to be proven at trial, but in no event less than the minimum jurisdictional amount of this court. As a result of defendant's above described conduct, plaintiff has suffered and continues to suffer great emotional distress and was prevented and will continue to be prevented from performing daily activities and obtaining the full enjoyment of life. As described in this complaint, defendant's conduct was done with oppression, fraud, and or malice, warranting significant damages, including punitive damages. Here, plaintiff was SA'd by Diddy, Shane, and Doe's 1 and 2 at Shane's residence. Plaintiff was legally on the premises as a guest and an invitee of defendant Shane. Defendant Shane, through renting the premises, had dominion and control over the premises where plaintiff was harmed. Defendant Diddy had dominion and control over the actions of defendant Shane and Doe's 1 through 3 and failed to step in and stop them from doing this to Ashley. As the owner of the property, Shane had a duty to protect Ashley from the harm she suffered at the hands of Diddy and Doe 1 and 2, and he breached his duty when he failed to stop them from SAing her. In furtherance of this breach, Shane encouraged Diddy and Doe's 1 through 2 to continue their assaults on Ashley. Ashley has suffered immensely because of Shane's intentional breach of his duty to her, and he invited you there for this to happen, allegedly, right? The sole purpose of him inviting you here to help him with his medicine and then you guys go zipping around in a car and watching a movie, he gets you water, and then he does this to you? Did he even suffer from what he said he was suffering from? He seemed just fine, right? Defendant's conduct described above was willful, wanton, and malicious. At all relevant times, defendants acted with conscious disregard for plaintiff's rights and feelings, acted with the knowledge of or reckless disregard for the fact that their conduct was certain to cause injury to plaintiff and intended to cause fear, physical injury, and or pain and suffering to plaintiff. By virtue of the foregoing, plaintiff is entitled to recover punitive damage. 15th cause of action is trafficking and Victims Protection Act, and this is against every single person. Defendants knowingly and intentionally participated in, perpetrated, assisted, supported, and facilitated a trafficking venture that was in and affecting interstate and foreign commerce together and with others in violation of 18 U.S.C. Among other things, defendants knowingly and intentionally recruited, enticed, provided, obtained, advertised, and solicited by various means. Plaintiff, knowing that defendants would use means of force, threats of force, fraud, coercion, and a combination of such means to cause plaintiff to engage in. Defendants had actual knowledge that they were perpetrating and facilitating defendant Diddy's abuse and trafficking conspiracy to recruit, solicit, entice, coerce, harbor, transport, obtain, and provide plaintiff into non-consensual acts through the means of force, threats of force, fraud, abuse of process, and coercion. Despite such knowledge, defendants intentionally paid for, facilitated, perpetrated, and participated in Diddy's violations of 18 U.S.C. 1590, which defendants knew and were in reckless disregard of the fact that defendant Diddy would coerce, defraud, and force plaintiff to engage in non-consensual acts. Defendants' actions were in and affecting interstate and foreign commerce. This is talking about what he was indicted on. I don't know if this necessarily applies to the case itself, but this is what Diddy's indictment was about. The trafficking and the interstate and foreign commerce. Foreign is not in the United States, right? By taking the concrete steps alleged in this complaint, defendants knowingly participated in this and furthered the enterprise. The concrete steps constituted taking part in the trafficking venture and were necessary for its success. The concrete steps constituted active engagement by defendants in the Diddy essay and cover-up enterprise. Defendants knew that its active engagement would lead to and cause trafficking. Defendants' affirmative conduct was committed knowing and in reckless disregard of the facts that Diddy would use his means and influence to force and intimidate plaintiff into engaging in acts. Defendants' conduct was outrageous and intentional. Defendants' knowing and intentional conduct has caused plaintiff serious harm, including without limitation, physical, psychological, emotional, financial, and reputational harm. Defendants' knowing and intentional conduct has caused plaintiff harm that is sufficiently serious under all the surrounding circumstances to compel a reasonable person of the same background and in the same circumstances to perform or continue performing activity to avoid incurring further harm. Defendants' criminal conduct in perpetrating TVPA violations was outrageous and intentional. It was in deliberate furtherance of a widespread and dangerous criminal trafficking organization. Defendants' criminal conduct also evinced a high degree of moral turpitude and demonstrated such wanton dishonesty to imply a criminal indifference to civil obligations. Defendants' criminal conduct was directly, specifically at plaintiff, who was a victim of the trafficking at this point in time. Defendants' outrageous and intentional conduct in this case is part of a pattern and process of profiting by undertaking illegal, high-risk, high-reward actions. Now, I do agree with that. As a side note, I do agree with that. Some of these actions allegedly are very high risk, therefore they're high reward. They can make a lot of money from participating in things like this because they are so high risk, right? That's why you're millionaires, maybe making a little extra income off of these high risk actions, or you're employees to millionaires may be making more money for aiding and abetting, allegedly, right? By virtue of these knowing and intentional violations of 18 USC, defendants are liable to plaintiff for damages she sustained and reasonable attorney's fees. By virtue of these intentional and outrageous violations of 18 USC, defendants are liable to plaintiff. 16th cause of action, aiding, abetting, and inducing a venture in violation to the Trafficking Protection Act, 18 USC. This is against everyone except for P. Diddy. Okay. Defendants directly committed and perpetrated violations of Chapter 77, Title 18 U.S. Code, including 18 USC, by aiding, abetting, and inducing the trafficking venture and the trafficking of plaintiff. Defendants themselves directly violated Chapter 77 by committing and perpetrating these violations. Among other things, defendants aided, abetted, and induced defendant Diddy's trafficking venture and trafficking of plaintiff, knowing that Diddy would use means of force, fraud, coercion, and a combination of such means to cause plaintiff to engage in these acts. I don't know if I can specifically categorize this specific event as trafficking because according to the lawsuit, Ashley wasn't taken from point A to point B for monetary gain, right? Unless someone like Shane was paid to get her from point A to point B, allegedly, right? She says this, she believes the car was payment, but there's no concrete evidence. So when we're talking about trafficking, we're talking about getting something from point A to point B in exchange for money by uses of fraud, coercion, XYZ, right? Defendants benefited both financially and by receiving things of value. That's exactly what I just explained, from participating in the cover-up enterprise venture. Defendants had actual knowledge that they were aiding, abetting, and inducing defendant Diddy and his co-conspirators' abuse and trafficking conspiracy to recruit, solicit, entice, coerce, harbor, transport, obtain, and provide plaintiff into acts through the means of force, threats of force, fraud, abuse of process, and coercion. Defendants knew and should have known that Diddy had engaged in acts in violation of the TVPA. Defendants knowing and intentional conduct of aiding, abetting, and inducing Diddy's violation has caused the plaintiff serious harm, including without limitation, physical, psychological, emotional, financial, and reputational harm. Through their unchecked support, defendants aided, abetted, and induced Diddy's violation and caused plaintiff harm that is sufficiently serious under all the surrounding circumstances to compel a reasonable person of the same background and the same circumstances to perform or continue performing activity in order to avoid incurring additional harm. Defendant's criminal conduct in aiding, abetting, and inducing defendant Diddy's violations of the TVPA was outrageous and intentional because it was in deliberate furtherance of a widespread and dangerous sexual abuse and cover-up enterprise and criminal trafficking organization. Defendant's criminal conduct also evinced a high degree of moral turpitude, and demonstrated such wanton dishonesty as to imply a criminal indifference to civil obligations. Defendant's criminal conduct was directed specifically at plaintiff, who was the victim of defendant Diddy's abuse and organization. Defendant's outrageous and intentional conduct in this case is part of a pattern and practice of defendants by profiting by undertaking illegal high-risk, high-reward partnerships. By virtue of these knowing and intentional violations of 18 USC, defendants are liable to plaintiff for the damages she sustained and reasonable attorney's fees. By virtue of these intentional and outrageous violations, defendants are liable to plaintiff for punitive damages. 17th cause of action, knowing beneficiary in a trafficking venture in violation of the Trafficking Victims Protection Act. Wow, there's so many causes of action here. And this is against everyone except for P. Diddy again. Upon information and belief, defendants knowingly and intentionally benefited financially and by receiving things of value from participated in, assisting, supporting, and facilitating an illegal coercive venture that was in and affecting interstate and foreign commerce together and with others in violation of 18 U.S.C. Defendants took many concrete steps to aid and participate in Diddy's cover-up enterprise venture. Among the concrete steps that defendants took to aid Diddy was providing victims to defendant Diddy, like plaintiff, as well as security, getaway driver, a private location to engage in his debaucheries, and drugs used to weaken plaintiff's defenses, making the venture possible. Upon information and belief, defendants' roles and actions provided were necessary for Diddy to force plaintiff to engage in these acts. The financing to the defendants in the cover-up enterprise directly formed part of the commercial nature of the acts. Defendants thusly actively participated in the recruitment of victims of the venture. You say that defendants thusly actively participated in the recruitment of victims of the venture, meaning that defendant assisted Diddy with finding victims to abuse, which could very well be true in what you're alleging. In this specific case itself, you all allege that Diddy recruited Ashley Parham because she said something about Tupac, right? And now in 319, you're alleging that the defendants actively participated in recruiting the victims. Where are you getting that from? I feel like the attorney has a lot of outside knowledge about P. Diddy, right? A lot of outside knowledge, a lot of people that she's represented, but I feel like you have to be careful to not bring things from other cases into your case specifically, right? That's how I feel about it, because you said that P. Diddy had a vendetta against Ashley, and that's why he did this. But here in 319, you say defendants participated in the recruitment of victims. How would Ashley know that? Or are you speaking as an attorney? Okay. I feel like the lawsuit should be unbiased. It should be fact-based. It should be based on the factual allegations, not things that the attorney may or may not know, right? Defendants knew or should have known they were feeding Diddy's deviancy. Upon information and belief, defendants received financial benefits from defendant Diddy and his venture, most notably a new car for Shane. Again, in the beginning, they said that Ashley Parham thinks the new car came from Diddy. You know, when you're basing your cause of action on something that is something that your client thinks. I mean, defendants knew that it would gain far from routine financial benefits by participating in the abuse cover-up enterprise trafficking venture. By virtue of these knowing and intentional violations of 18 U.S.C. 590, defendants are liable to plaintiff for the damages she sustained and reasonable attorney's fees. 18th cause of action, obstruction of the enforcement of the Trafficking Victim Protection Act, 18 U.S.C. This is against everyone but Diddy. Okay, defendants knowingly and intentionally attempted to obstruct, interfered with, and prevented the enforcement of 18 U.S.C. 1590, all in violation of 18 U.S.C. 1590. This activity is hereinafter referred to collectively simply as obstruction. Upon information and belief, defendant's obstruction of 18 U.S.C. 1590 was forbidden by 18 U.S.C., thereby violating Chapter 77, Title 18. Defendant's obstruction described here and in the preceding paragraph directly, proximately, and foreseeably harm plaintiff by directly resulting in her being forcefully and against her will to engage in these acts. And upon information and belief, Diddy has a well-documented history of criminal investigations. We can say that's true. We know that to be a fact. Defendants were on notice of Diddy's proclivity to criminal activity. They knew or should have known that defendant Diddy's abuse and cover-up trafficking operation would or could result in a criminal investigation by state and federal prosecutors for violating, among other laws, the TVPA. Defendants should have taken a cue from the federal prosecutor's arrest and prosecution of Jeffrey Epstein. Whoa. The U.S. Attorney's Office for the Southern District of New York indicted Epstein and unnamed associates for violating the TVPA. Later, the same office indicted Epstein's co-conspirator, Ghislaine Maxwell, for conspiracy to entice minor victims to travel to be abused by Epstein. I like that. I like the way she put that in there. Because Shane allegedly enticed Ashley to travel to help him with his medication to be abused by Diddy, right? All named defendants in this matter engaged in the same activities as Mr. Epstein and Miss Maxwell. In fact, defendants may have done worse. That's a big allegation there, okay? Upon information and belief, by concealing their actions thereafter, defendants obstructed, interfered with, and prevented the state and federal government enforcement of the TVPA against Diddy to the extent that the government was able to untimely charge Diddy with TVPA violation. The filing of those charges was delayed by defendants' actions. Because of that delay, plaintiff was forced to engage in these acts. One example of how defendants attempted to obstruct, interfered with, and prevented state and federal government's enforcement of the TVPA. These defendants provided resources to Diddy, like security, victims, drugs, getaway driver, and false alibis so that the acts would escape the detection of state and federal law enforcement and prosecuting agencies. Now, okay, I understand what the attorney is saying here. She's saying that they aided and abetted Diddy, essentially. What he said went, because money is power and money is law. So if they had to look the other way while he did something really terrible, sometimes the money took precedence over that, allegedly, right? But we need to also hold these enforcement agencies accountable too, because it's not necessarily the defendant's duty to get justice, right? It's not necessarily their duty. We need to ask, why was it undetected for so long? In this lawsuit, they say it's because he had so many people shielding him, right? But it makes you think he had to have a couple people on the inside, because these types of crimes, thousands and thousands, and hundreds of allegations, don't go under the nose of the federal government, don't go under the nose of the state government. So what exactly is really going on here? It says here by 25 that defendants provided these resources to further the cover-up enterprise venture with the purpose of helping Diddy and the other defendants in evading criminal liability for violating the TVPA. By providing this type of support for Diddy, defendants intended and knew that Diddy's depraved and egregiously forced acts would escape the detection of law enforcement and prosecuting agencies for some period of time. Defendants' support furthered the Diddy abuse and cover-up enterprise venture with the purpose of helping Diddy evade criminal liability for violating the TVPA. Upon information and belief, defendants' obstruction, attempted obstruction, interference with, and prevention of the enforcement of the TVPA were all done intentionally and knowingly. For example, defendants knew that Diddy was high risk, specifically high risk to violate the TVPA, through continuing these activities due to his proximity to criminal activity as far as 1991. And upon information and belief, defendants were aware and participated and engaged in witness intimidation and bribery to escape criminal liability, including offering Ashley money to say that the SA she suffered was consensual, and for a plaintiff to say that she was just a worker. The allegations, you say that Diddy offered her that money, right? Okay, I'm just making sure. Defendants were fully aware that there were public allegations that defendant Diddy's illegal conduct made through complaints in previous lawsuits. Defendants concealed information from the federal government in an intentional attempt to obstruct, in many ways, interfered with, and prevented the enforcement of the TVPA by investigators and prosecuting agencies. Upon information and belief, defendants' relationship with Diddy went far beyond a normal and lawful partnership, relationship, and friendship. Defendants knew and intended that its relationship with Diddy would go beyond a normal relationship. Defendants knew that its decision to go beyond a normal employment and personal relationships with defendant Diddy obstructed the ability of law enforcement and prosecuting agencies to enforce the TVPA. Upon information and belief, defendants' obstruction of the government's TVPA and other law enforcement efforts was intentional and willful. Therefore, defendants intentionally and willfully caused Diddy's commission of the forcible acts with plaintiff through its obstruction, supporting the concealment of the cover-up enterprise venture. Defendants knew that Diddy would use means of force, threats of force, fraud, coercion, and a combination, they are using the RICO hot words here, and a combination of such means to cause plaintiff to engage in these acts. Upon information and belief, defendants knew, acted in reckless disregard of the fact, and should have known its obstruction in violation of 18 U.S.C. would directly and proximately lead to unlawful and forceful acts by Diddy with individuals like plaintiff. Upon information and belief, defendant's obstruction has caused plaintiff serious harm, including, without limitation, physical, psychological, financial, and reputational harm. That harm was directly and proximately caused by the obstruction, and the harm resulting from obstruction was foreseeable. Upon information and belief, defendant obstruction has caused plaintiff harm that is sufficiently serious under all the surrounding circumstances to compel a reasonable person of the same background and in the same circumstances to perform or continue performing activity to avoid incurring further harm. Upon information and belief, defendant's criminal conduct in obstructing enforcement of the TVPA was outrageous and intentional because it was in deliberate furtherance of a widespread and dangerous criminal trafficking organization. Defendant's obstruction also evinced a high degree of moral turpitude and demonstrated such wanton dishonesty as to imply a criminal indifference to civil obligations. Defendant's actions were directly, specifically at plaintiff, who was the victim of the abuse and cover-up trafficking organization. By virtue of these violations of 18 U.S.C., defendants are liable to plaintiff for the damages she sustained and reasonable attorney's fees by operation of 18 U.S.C. 1595. Defendants perpetrated an obstruction of the TVPA and therefore perpetrated a violation of Chapter 77, Title 18. Now we have a 19th cause of action, and that is false imprisonment. And this is against everyone except for the driver who was just in the car, right? I think the driver was Doe 3. Defendants intentionally detained or prevented plaintiff from leaving the premises, therefore imprisoning plaintiff, acting in deliberate malice and for the purpose of S.A.ing plaintiff. Defendants imprisoned plaintiff without just or reasonable cause, without lawful privilege, without plaintiff's consent, and or without probable cause for an appreciable amount of time, and therefore deprived plaintiff of her personal civil liberties. Defendant's unlawful conduct resulted in the false imprisonment of plaintiff on March 23rd, 2018. Plaintiff was invited to defendant Shane's home as a guest. Plaintiff was under the impression she was in a safe environment where only she and defendant Shane would be present. On or about the date enumerated above, plaintiff's clothes, phone, purse, keys, and cell phone were hid and confiscated in an effort to prevent her from leaving the premises after Diddy and other defendants arrived at Shane's residence. Lastly, Shane's home was positioned in a way where there was only one way to ingress and egress. Defendants forced plaintiff against her will and over her protest with threats of physical violence, and then forced plaintiff to engage in non-consensual activities with Diddy, Shane 1 and 2. Plaintiff was not released from her imprisonment until she made her escape, as enumerated above. Plaintiff believes that procuring her false imprisonment was made intentionally, with actual malice, and was intended to harm plaintiff solely for the purpose of the gratification of Diddy and in furtherance of the cover-up enterprise. Malice is an attribute to Diddy's actions as a joint tortfeasor in that he joined and facilitated the false imprisonment and maliciously instigated it. Malice is also an attribute to Doe 1 as security personnel for Diddy, whose actions independently based on the fact that defendant Diddy wanted to prevent Ashley from being able to escape. As a legal result of these defendants' actions, plaintiff was physically, mentally, and or emotionally injured, all to an extent and in an amount subject to proof at trial. Defendants acted with malice and with the intent to cause injury to plaintiff, or acted with a willful and conscious disregard of the rights of plaintiff in a despicable manner. In addition, defendants engaged in despicable conduct that subjected plaintiff to cruel and unjust hardship in conscious disregard of her rights. Therefore, plaintiff entitled to an award of punitive damages for the purpose of punishing those individual defendants to deter them and others from such conduct in the future. As a proximate result of the acts of the defendant, plaintiff has suffered great damage to her person, reputation, and embarrassment. As an appropriate result of the acts of the defendants, each of them herein alleged, plaintiff has been and will continue to be prevented from having a normal life. The amount of damage done to plaintiff is still ongoing and not fully known at this time. As an additional approximate result of the acts of defendants, plaintiff was injured and her health, strength, and activities sustained shocking injury to her nervous system, an injury to her body requiring several hospitalizations, treatments from therapists and other medical professionals. All of these injuries have caused plaintiff to suffer extreme and physical severe pain and mental anguish. These injuries will result in some level of permanent disability to the plaintiff. As a further proximate result of the acts of defendants, plaintiff was required to and did employ physicians, therapists, and other medical professionals, including hospitalizations for medical records, treatment, and care for the injuries resulting in her SA. Plaintiff did not incur medical and incidental expenses for the services of all those hospitals and doctor's visits to date. The acts of the defendants, each of them herein alleged, were willful, wanton, malicious, and oppressive, justifying the awarding of punitive damages. Wherefore, plaintiff respectfully requests judgment against defendants, awarding compensatory, consequential, exemplary, punitive, restitution, unjust enrichment, equitable, and treble damages in an amount to be determined at trial, cost of suit, attorney's fees, and such other further relief as the court may deem just and proper. Demand for jury trial. Pursuant to Federal Rule of Civil Procedure, that's 38B, plaintiff demands a trial by jury on all issues so triable. Respectfully submitted by Sean and Ariel Mitchell. Now, I've read Cassie's lawsuit. If you haven't checked that out, please check that out because it was the first groundbreaking lawsuit in this case. Now, I decided to read Ashley Parham's because I felt like it was another groundbreaking case that needed to be covered because I'm starting to see a pattern in these lawsuits as far as the defendant isolating women or people he feels are vulnerable. He isolates them from a situation. He pulls them out of their comfort zone and isolates them. And then the attack starts. And the attack is usually alleged to be with more than one person. So you think isolated person and then attacked by two or more persons. I've seen this and at least 3 or 4 Diddy lawsuits where the woman was taken from where she was or asked to come somewhere else, and then more than one person attacked her. And allegedly, someone was filming, and allegedly, this was being repurposed for something else. So I think it has a lot to do with filming. I think it has a lot to do with money. I think it has a lot to do with power and control. But the fact that these lawsuits are following a certain trend lets me know that there is some truth there, allegedly. You know what I'm saying? If you look over the lawsuits, they all seem to fall in line. There's more than one man and a woman. Even with Cassie. More than one man, freak off, and a woman. Here, more than one man and a woman. Several other lawsuits, more than one man and a woman. He's watching. He's liking that. I don't know. Let me know what you guys think. Do you guys believe the validity of this lawsuit? Let me know. If there are any other lawsuits you want me to cover in depth, let me know. Make sure to let me know the lawsuits you want me to cover. I want to thank each and every one of my followers. We're on the road to 2,000. And I want you guys to have a great rest of your day. Bye now.